are the scope of representation, the disclosure section, and the good faith provisions. The scope of representation is limited. It is a limited purpose representation. It is a representation that is solely for the purpose of reaching a comprehensive settlement. It clearly states that the attorney will not represent the client in any adversarial proceedings or assist in any litigation. If any adversarial proceedings arise, the attorney must withdraw. Further, it states that the attorney will not be called as a witness in litigation and will not provide any evidence in any litigation, should any litigation ensue if the collaborative process is unsuccessful. The client can terminate the collaborative process at any time, but if the client does so, all parties must withdraw. Certainly the attorneys must withdraw. If the spouse elects to terminate the collaborative process, again, the attorneys must withdraw. The attorneys will not file an appearance in the case, and they will not be attorneys of record because, again, it is a completely non-litigated, out-of-court process until final agreement is reached, and then an appearance is filed solely to secure a prove-up date and enter the judgment. The disclosure is different. Again, it is an out-of-court, non-litigated case, so all of the traditional discovery process doesn't apply. There is no discovery, there's no notice of produce, there's no interrogatories, there are no formal disclosure statements, there are no pleadings, there are no hearings. It is a completely voluntary process, but complete and full disclosure is absolutely mandated. There's no limitations on what can be requested and produced in disclosure except anything, of course, that's not privileged, that's privileged or confidential. But otherwise, all relevant materials that either attorney requests must be produced. And relevant means material of the kind is the kind of information a reasonable decision maker would want to know and want to have available in order to make a sound decision. And it's really up to the attorneys to make that determination and to request the documents of the clients. And the client's compliance is required, and it is something they agree to when they sign the retainer agreement and the participation agreement. So the clients make a commitment to full disclosure regarding the nature and extent and value of all of their assets, any income, and they make a commitment to inform all parties of any new developments that should occur relating to anything financial or anything that pertains to the case, if anything like that should occur while the case is in process. The clients also authorize their attorneys to make all such disclosures to their collaborative counsel counterpart and to the other spouse as the attorney in his or her sole discretion deems is necessary. Now, of course, the attorney-client relationship, the confidentiality of the attorney-client relationship persists, and if the client insists that some disclosure to the attorney is confidential and should not be disclosed, the attorney is duty-bound not to disclose it. But that might lead the attorney to make a determination that a positive collaborative case cannot proceed, and that might be a cause to withdraw the representation and to end the case. A client's persistent failure and refusal to provide disclosure requested by the attorney will be deemed constructive termination of the collaborative process. Another important section of the retainer agreement pertains to good faith. Collaborative process, a collaborative divorce, is a completely voluntary process. The parties need to be committed to behave in a manner that is good faith. And the success of the process really depends on the good faith of the parties. No attorney can guarantee this. The attorneys need to be very clear and alert the client that if they suspect any bad faith on their client's part or the other part, they will make that known to everybody involved, and that could terminate the process. And of course, no attorney could guarantee the good faith of the other parties or their own clients. So that needs to be clearly disclosed, and that's a risk of the process that the client needs to be aware of. I would like now to turn our attention to the participation agreement. This is a very important document that the parties need to understand comprehensively, and they must sign it in order for a true collaborative case to proceed. So once a client has expressed interest in collaborative divorce, and the attorney has spent enough time to getting to know the client and determined that the client is a good candidate for collaborative divorce, and the retainer agreement is reviewed and signed, the attorney then turns their attention to the participation agreement and goes over it in great detail with their client, so the client is fully aware of really everything that's expected in the process. So I'd like to touch on the key parts of the participation agreement now. The first section of the participation agreement talks about the goals. We want our clients to be on board with the goals of the collaborative divorce process. Of course, the most important goal is to resolve issues without litigation. The client needs to have a goal of commitment to honesty, integrity, cooperation, and professionalism. The client needs to know that another goal is considering all possible options to maximize opportunities for settlement. It is a concept of open-mindedness and really exploration of all the different options and opportunities that might be involved in moving their family into a new direction. There has to be a commitment to full, honest, and timely disclosure without formal discovery. That's an important goal and an important commitment that the client makes. Also, the client commits to promptly updating information when any information changes. The client makes a commitment to open face-to-face negotiations, 4-way meetings or 6-way meetings, however many people are involved in any particular case, is a critical part of the collaborative divorce process, and the client needs to understand and commit to participating in face-to-face negotiations. Again, the participation agreement also goes over the cautions so that the client understands that the risks involved in a collaborative case, and although the way a collaborative case usually works, they're not great risks, but the client needs to understand what the risks may be. Of course, there's no guarantee of success. Statistically, there's a very high percentage of success in collaborative cases, and I just want to say that as a note. Typically, it is a process that works very, very well, but there's no guarantee of success. The success depends on the clients, their good faith, their honesty, and their participation. With good support, with a well-trained collaborative team, that usually can be evoked from the clients, and that usually can work out quite well. But again, the clients need to understand that it is ultimately up to them to behave in a way that shows good faith, honesty, and participation. During the collaborative process, all rights to formal discovery are waived. There are no hearings, and there's only use of common experts instead of each party using their own expert. Again, the parties need to understand and agree to that. The collaborative process involves vigorous good faith negotiations, and each attorney has the professional duty to represent the clients, to their clients, competently and diligently, and to advocate for their clients. But they do so in an interest-based, problem-solving method of negotiation, not in the traditional litigation format. And again, the clients need to understand that it is a different type of representation. And they are cautioned that despite best efforts, an acceptable agreement may not be reached, and that either party may terminate the process and withdraw at any time. There's a section that talks about integrity and good faith. A critical component is protecting the privacy of the parties and respecting their privacy. A high standard of integrity is required. Parties need to commit to not taking advantage of another party's mistake or misunderstanding, and to really work in a way that's cooperative. They have to commit to informing the other party of any significant changes that arise, and to commit to taking a reasoned position in all disputes in an effort to create proposals that will meet the needs of the entire family. They need to commit to not threaten litigation and to prioritize their children's issues when children are involved. Not just the clients sign the participation agreement. All the professionals that are involved in the collaborative case are parties to the participation agreement. Each attorney, as I stated, is independent from the other, and each represents only one party. Another critical component is confidentiality. The parties agree that all discussions between the parties and their attorneys and all parties in the professional team and any document produced, all of that will be deemed privileged settlement negotiation, and therefore will not be disclosed and will not be subject to discovery should the collaborative case terminate before it's settled. I'd like to switch gears now and talk about how an attorney might interview a client and work towards determining whether a client would be a good candidate for collaborative divorce, or really more importantly, what kinds of things might disqualify somebody from being a good candidate. Because I'd like to start with the assumption that most couples would be good candidates for collaborative unless there's certain really overriding interests that would just be disqualifiers. So let's take a look at what kinds of things that we would need to consider. And these considerations come through pretty extensive discussions. I usually spend 1.5 to 2 hours with my client really getting to know them, getting to understand their relationship with their spouse, with their children, the dynamics of the household, the dynamics of the economics, in order to really gauge and have an assessment of whether or not I would recommend collaborative. So it may seem like a quick process based on what we're going to discuss, but it really is much more comprehensive. But in the discussion, I really try to understand the goals of my client and whether they involve a preservation of the relationship so they could co-parent, whether my client really is prioritizing the children, and whether my client believes that their spouse is interested in prioritizing the children. Whether my client is motivated by having control over the outcome rather than leaving the outcome in the hands of the court, and whether that is an important consideration, because that is one of the most important driving considerations, is maintaining control over the outcome, and whether they're willing to work hard to be able to do that, to be the architects of their own settlement, including working with me to really identify their needs and interests, working with the entire team and cooperating in a way that a settlement can be crafted. I try to see what level of anxiety my client has and whether they really can sit face-to-face with the spouse in a supported environment with the coach present, and whether they are somebody that could sit and have a face-to-face discussion with their spouse in that kind of a supported environment. Whether they're ready to participate emotionally in a dispute resolution process, or whether possibly they need some counseling and some emotional support before they can begin with the process, is an important assessment. We discuss at length the relationship that they have, the parties, and whether I get a sense that the client believes in the trustworthiness of their spouse, or whether has significant doubts about whether the spouse can disclose honestly the assets. That also comes through a discussion of the control of the assets and each client's involvement in the family finances. I try to get a sense of whether there's any information that my client might be hiding or unwilling to share, because that would be a very determinative issue when it comes to considering a collaborative divorce. Issues that would come up that would probably preclude a collaborative divorce is any history of coercive or violent behavior on either party. If there are particularly difficult issues that need to be resolved, such as IRS problems, fraud, or physical or mental abuse when it comes to the parties or the children, those cases might be too difficult, are likely too difficult and not not appropriate for collaborative divorce, and court intervention most likely would be necessary, certainly in any instance of abuse. We need to determine whether the client is interested in participating in a process of voluntary disclosure, and getting a sense of whether the spouse would be interested in that as well. It's important to determine a client's ability to express their needs and their ability to listen actively. But again, a lot of that comes through coaching and support, and it's not expected that a client comes into the office with those skills and ready to hit the ground running. A lot of that really, it behooves all of the professionals that support the process to facilitate that in their clients, support that, and educate them. And a very important determination is if there's any factors that would undermine the client or the spouse's ability to make reasonable decisions. And that would include any history or ongoing issues with substance abuse, mental illness, fear, or coercion. Those are very important issues to unearth if they are there before any collaborative process would be recommended. Discussing the client's expectations as to timing and process are also important to make sure that the collaborative process is really something that would be in line with their expectations. Now, having said that, it would seem from everything we just discussed that there aren't that many parties that would come to a divorce that would be good candidates. Because certainly when a couple reaches a crisis in their relationship to the extent that they want to terminate their marriage, chances are there's not a lot of communication, trust, or cooperation. So how does anybody ever become a candidate for collaborative divorce? In fact, it's quite natural for couples to come to the divorce process with lack of trust, with lack of communication, and with a very stressed relationship. And it is for those couples that collaborative divorce really can work miracles, because the collaborative team really comes in and supports the couple in managing the trust, the anger, managing the anxiety and the stress that can interfere with constructive interest evaluation, constructive goal evaluation, and constructive communications that move the parties forward, focusing on those topics. Just by way of example, I had a case a collaborative case that completed in 9 months and was very successful. And at the start of the case, the parties both had committed infidelity. There was a high degree of mistrust. One party was accusing the other of stealing the party's belongings, jewelry. There was a tremendous amount of tension and animosity, a lot of fighting. But there were common goals. They had a daughter and they prioritized her, and they wanted to minimize emotional impact. Neither of them really wanted to litigate because they wanted to avoid the expense and the stress and the time. And they just wanted to complete the process quickly. Those were enough common goals that with a good support team, we were able to complete a successful, positive, collaborative divorce. And by the end of it, the husband invited the wife out for lunch to celebrate the divorce, and they were planning on how to celebrate with their daughter. So it can work miracles. It can be very successful, and for a much broader range of clients than one would initially think when we really look at everything that's required for a collaborative process to work. Again, because it's the team that creates the safe environment and creates the process and creates the education and the support for the clients to be successful. Next, I would like to turn our attention to the actual collaborative divorce case. Now that we know the shift in the philosophy of the attorney that wants to be a collaborative divorce professional, and we understand how we evaluate a client to consider whether collaborative divorce is something that's appropriate, and we understand the retainer agreement and participation agreement that need to be part of the collaborative divorce case, what does the actual case look like and how does that flow? That's what I'd like to address next. First, of course, it starts with a meeting with the client to evaluate if the client is appropriate for the process, and that's what we just discussed. Once the first initial meeting is completed and the client is actually interested in pursuing a collaborative case, we want to inquire whether the spouse has retained an attorney, and if they have not, we make recommendations about other collaboratively trained attorneys, and we also discuss maybe sharing some literature and information with the spouse so that the spouse could be educated and hopefully interested in the collaborative process. Of course, we explain the retainer agreement and the participation agreement to the client, and comprehensively and in a lot of detail. Next, the retainer agreement is signed. After that's in place, and hopefully both spouses have retained collaborative attorneys, collaboratively trained professionals, next comes the first meeting between the collaborative counterpart attorneys. This first meeting is very important because it really lays the groundwork for how the case is going to be managed and handled. First, the attorneys would discuss their philosophy of how they handle the case. They discuss important administrative things that can really interfere with the smooth flow of a case, and they would go over things like how they handle communications and emails, and whether they limit emails to just administrative issues or whether they actually discuss substantive issues on email, which might not be recommended because people tend to become much more positional when they're communicating in writing versus an open dialogue. So again, that's something that should be discussed thoroughly in terms of attorney philosophies. How they want to manage meetings and briefing before a meeting and debriefing, whether they want to come earlier and just talk before the clients arrive so they're not wasting the client's time, to make sure that they look prepared and ready. So